This is Radio Law. This is Dr. John Olsson. Welcome to this audio blog. Today I'm asking the question whether Pistorius's putative self-defense excludes the defense of involuntary action. There are many troubling aspects of the Pistorius trial and appeal, but in this piece I'm going to just concentrate on one area, namely Oscar Pistorius's defense. Pistorius's defense was that he feared for his life. He feared that there was a person behind the toilet door who intended to do him harm. However, this defense appeared to change under cross-examination to one of involuntary action when he said, "When I heard a noise inside the toilets, before thinking, out of fear, I fired 4 shots. Prosecutor Gerry Nel immediately realized that this was technically a change of his defense, and he retorted, "Your defense has now changed, sir. Putative self-defense to involuntary action, that is what I hear." And he asked Pistorius whether he realized that he could not have 2 defenses. Pistorius replied that he realized that. So although Prosecutor Gerry Nel described this as a change of defense, I wonder if it is. Are putative self-defense and involuntary action necessarily mutually exclusive? I mean, not legally, but in cognitive terms. The law says they are mutually exclusive, incompatible, if you will, but can we be sure that the brain works in the same way as the law does? Is it not possible to be simultaneously in a state of fear and at the same time to act without thinking? In fact, is it not highly likely? It must be the case that putative self-defense is what we may term a continuous state of mind. A person perceives an imminent danger to themselves and continues to experience that sensation. Now, we are not at our most rational when in a state of fear. We are not likely to be able to act in a logical or rational manner. In the course of feeling this imminent danger, it seems to me likely that a person could also be prone to acting, quote, without thinking, unquote. So when Pistorius says, "When I heard a noise inside the toilets, before thinking, out of fear, I fired 4 shots," this is not necessarily an accurate description of an involuntary action. It is a post facto rationale of what the defendant believed happened and what he believed he did. It is not a statement that his action was involuntary. It is a summary, a revisiting of how he felt at the time. Now, what I am putting forward here is the hypothesis that I believe the court may not have taken into consideration at appeal. I think in order to answer these questions, expert psychiatric evidence would be required, not just an academic analysis, but an investigation which took into account all the circumstances of the case. I do not believe the judges who made this decision know enough about how the human mind works to make their decision accurately, and I do not believe that they fully understood the psychological makeup of Pistorius himself, and I consider that this matter needs to go back to the appeal court with the benefit of expert psychiatric evidence. Moreover, to take the adversarial sting out of the case, I believe the court should appoint the expert, and it should be a single expert or panel of experts. We should not be looking at a situation where experts are hired by the parties, either by the state or by Pistorius's legal team. There are other aspects of the case which are legally troubling, and I will discuss them in later videos. Thank you for listening, and goodbye.